Clerk will call this matter.
Case number C-12-1282, United States versus City of Seattle. Counsel, please make your appearances for the record.
Morning, Your Honor. Mike Diaz for the United States.
Good morning, Your Honor. Tim McGatt for the United States.
Christina Fogg for the United States.
Thank you.
Peter Holmes, Seattle City Attorney.
Mr. Holmes.
Good morning, Your Honor. Josh Johnson, appearing for the City of Seattle.
Mr. Johnson.
Ian Warner, Mayor's Office, Legal Counsel.
Thank you.
Isaac Ruiz on behalf of the Community Police Commission.
Thank you. Ruiz. Counsel, I do not anticipate that today's hearing is going to be a long one. I'll make a few brief introductory remarks to set the stage here. Then I would like to hear from the Department of Justice, from the city, and from the CPC. And then it's my intention to provide you with some guidance about where we go from here. So, in terms of setting the stage, would remind you that in October of 2016, the city filed the proposed legislation with the court. We gave ourselves a relatively short period of time in order to comment on that. And in what is found in the docket at 357, January 6, 2017, there's an order granting preliminary approval and setting out some areas of concern. The court then does not have an active role in this while legislative consideration is underway. I would note that in addition to considering the proposed legislation, there were also numerous amendments to some pending terms and to some new areas that have never before been considered by the court. On May 22nd, 2017, the City Council passes the ordinance, and on June 1, 2017, the mayor signed it. I am not involved in what has happened since the mayor signed it, and I know nothing about it other than what I read in the newspapers, but it's clear that there is a collective bargaining process underway, which became somewhat newsworthy yesterday. So I asked that we have this status conference, and I set it for today with the expectation that I would hear from the parties and then give you some suggestions of where we are at the present time. So against that backdrop, I'm not sure who's speaking for the government today. Mr. Diaz, is that you?
It is me, Your Honor, but the city as a moving party is the moving party, so we would defer to them to go first, if that's okay.
All right.
Good morning, Your Honor. May it please the court, I'm Pete Holmes, City Attorney for the defendant, City of Seattle. There are many people from the city here today, Your Honor, but I would like to take just a moment to introduce three of them. City Council members Burgess and Gonzalez are behind me to my right, along with Deputy Chief Carmen Best.
Mr. Burgess, would you stand up, please? I think we're losing you sometime this fall. Not in the sense of you're getting lost, but going on to other things. But I will tell you that I'm going to be lost without you. I thought you've been a very responsible voice in this process, and I have appreciated your efforts. So you'll be missed. Ms. Gonzalez, wherever you are there, welcome to the club. I applaud the work that you've been doing. I think it's represented the best of what the City Council has to offer. Look forward to continue to work with you. And Assistant Chief Best, who's back there somewhere, you have big shoes to fill today, but I expect you not to speak with an Irish accent. So. Thank you. Please continue, Mr. Holmes.
Thank you, Your Honor. As the court is aware, our 5-year police reform effort, nearly 5 years, has produced remarkable results within SPD, particularly on the use of force, as confirmed by a series of positive assessments from the court's monitoring team. Most recently, the City Council has focused on legislation to institutionalize SPD's permanent accountability structure. Throughout, the Executive has bargained in good faith with the Seattle Police Management Association and Seattle Police Officers Guild. My office has simultaneously managed a considerable amount of related litigation, including these federal proceedings as well as state, court, and administrative matters. As directed by the court, I intend to provide a broad overview of the present status of Seattle's police reform effort, key to these legislative, collective bargaining, and litigation activities, and with reference to our last two status conferences on August 15, 2016, and January 4 of this year. Regarding the accountability legislation in front of the court, following that last status conference on January 4, the court issued an order approving, with certain caveats, the proposed accountability legislation that had been submitted last October.
Approved it for what? Because it seems to me we part company on that particular question. I approved it to go to the City Council. Certain parties in this proceeding have viewed that as an opportunity to say, the court blessed it, we're never going to look back at it. That's not the situation.
Yes, Your Honor. We are back here today specifically to talk about what was different between October and the legislation that was submitted, the legislation that was originally proposed in October and that which is accompanying the motion today. The city's June 21 brief, in fact, Your Honor, it attaches the entire accountability legislation package, and the brief itself focuses solely on those differences between the original submitted legislation and that which is attached to the 21 brief, June 21. It outlines every provision, Your Honor, that the City Council passed in late May and was signed by the mayor on June 1, but every provision that contains a substantive change from the provisions that the court conditionally approved, if that's an acceptable term, in January. The brief explains further which additions and changes are consistent with the consent decree, and I will not repeat here what has been set forth in the city's June 21 brief except to answer any questions the court may have.
Well, the fundamental question that I have is, you're giving me a work in progress and asking me to approve it. And that seems to me to be somewhat of a rush to termination and premature. You have, it seems to me, a very significant issue going on right now that broke out into the public on Monday when the mayor, apparently independent of labor negotiations, implemented the body camera procedures. How is it that you want me to say what's there now is okay when it potentially is impacted by developments that I can't predict and I'm not involved in?
It is our hope, Your Honor, that with approval and guidance from the court, that the ongoing collective bargaining negotiations can be pushed further. We recognize, as I stated to the court at the January 4 status conference, that we had a problem. We have to continue bargaining in good faith while we try to make progress on the accountability legislation. It's the situation, Your Honor, it's the process that the city collectively, the council and the mayor, the executive, have elected to move forward. If we stop and wait to bargain every element with the unions, we may not be back before the court for some time. But this was a decision that was made by the city as a way of continuing to advance the police reforms with ongoing guidance from the court while we meet our collective bargaining obligations. It is a difficult situation.
Well, it's difficult, and let me hypothetically suggest the following situation. There is a provision in the accountability package that sets out a certain procedure to be followed. In the course of negotiations with the various labor unions, there is a result which undermines some portion of that process or undermines some portion of the accountability effort. And I'm then going to have to go back and undo the provision in the ordinance which no longer accurately ensures or procedurally ensures constitutionality in police practices. That's what my dilemma is, and it seems to me that there's little consideration on the part of, well, we're going to work this all out, let's get this stuff in place on some kind of provisional approval, and then depending on what happens in contract negotiations that I'm not a party to and I don't influence, at least other than from the bully pulpit up here, having to undo things that have been created and are in effect.
Indeed, Your Honor. You have previously admonished the parties that you did not want to be, the court did not want to be in the position of vetoing legislation that had been enacted by City Council. We appreciate that as well. Unfortunately, Your Honor, that's a fairly accurate description of what is a complex situation, of simultaneously negotiating with two unions, moving forward with legislative authority to institutionalize the police accountability structure, while observing the requirements of the consent decree. It is a difficult situation, Your Honor. Our proposal, however, is that we keep, this is in effect a second trip here to the court to inform the court of our progress on the accountability legislation while bargaining. That bargaining is difficult. The last time I was here, I suggested that one of the possibilities might be that if every party was here in the room before the court, that might get through some of these issues that we have. Short of that, Your Honor, this seems to be the process that circumstances have dictated.
Well, we informally know that as the Holmes party interpleader proposal, and it got the attention that it deserved. You know, I can't very well order people who aren't in front of me to just show up and participate. So,
no,
as much as I would like to.
You're correct, Your Honor.
Please continue.
Correct, Your Honor. And no, I was never suggesting that the court order parties to appear. But the joinder issue is something that perhaps we will revisit. For now, the course is to attempt to do simultaneous collective bargaining and work on the legislation.
Well, there is only one amicus that I'm aware of which has said, Judge, whatever you do, you have to allow contract negotiations to go forward. And that was the CPC, which was surprising since it seems to me that ultimately that's contrary to the public's best interest. But if that's the case, then it seems to me one option is simply to say, Judge, we've reached an impasse in the contract negotiations. We wish to go forward. Please give us judicial authorization to do this. Somewhat similar to what the mayor apparently did on Monday when he got, I'm going to use my phrase, got tired of trying to deal with some party that wouldn't agree to a reasonable compromise or wouldn't agree without some compensation to flow from it, and then suddenly just said, all right, then we're going to implement it. Doesn't that undercut your position that I'm hog-tying you?
I would not take the position that the court is hog-tying us, and certainly yesterday's action by Mayor Murray, Your Honor, was
interesting slip there, but
a Freudian slip, Your Honor. But the action by Mayor Murray, I think, demonstrates the practical problems that the city faces. We have ongoing encounters with community members and the police department, even while we're trying to reform it. Even while we're trying to comply with the terms of a 5-year-old consent decree, even while we're trying to negotiate the impacts with our two police unions. It is a practical, complicated situation, Your Honor, and this is the one that we have in front of the court today.
Well, you know, takeaway is your bottom line, that the Constitution trumps everything else. And, you know, against constitutional principle, labor contracts will fall. And that message should come across loud and clear. As I've said before, I have no idea what goes on in those negotiations. At least one newspaper has reported that the various provisions in terms of accountability and police practices are being held captive to a pay increase. I've already spoken to that, and I'm not going to back down from it. The citizens of Seattle are not going to pay blackmail for constitutional policing. That's simply the bottom line.
Your Honor used the term impasse a few moments ago, and that is a labor term that could indeed occur if we are not able to make significant progress. That formal declaration has not occurred, and until that does, we need to continue bargaining. If there is impasse, then there will be arbitration proceedings that ensue at that point, Your Honor.
All right. I keep interrupting you.
No,
Please
that's
continue.
quite fine, Your Honor. We do fully request that the court approve this legislation if the court is willing to indulge this process that we have at present to approve the accountability legislation that we've submitted. And we will continue to bargain, as I've said, in good faith. And to the extent, though, that the bargaining itself leads to changes in the legislation now in front of the court, it is the city's intent to bring those changes back to Your Honor for the court's review and approval before they would be implemented.
But does the city understand that that may impact not only changes that are made in the negotiations, but changes to the existing ordinance to reflect those changes?
Yes, Your Honor. And the ordinance itself reflects that bargaining is required, court approval is required, and consequently, even the legislative process contemplates that further amendments, subsequent amendments may be required.
All right. I believe it's in your briefing, 396, page 25 of 26, footnote 78. You make the offer that to the extent the court requests, the city can provide a full list of provisions which are subject to collective bargaining. I do not intend to approve the ordinance today because I need to see that, but I'm taking you up on your offer. That will assist me in determining if there are portions of the ordinance that I feel can go forward. But right now, I don't know what's subject to collective bargaining, and you can understand that ambiguity is very concerning to me.
Correct, Your Honor. We do have one situation where at least 4 body cams. I think the city, the city has taken a position, the executive has taken a position that in light of the impacts of community police interactions that are ongoing without the aid of body cams, that was something that needed to be unilaterally implemented. And that is the reasoning behind Mayor Murray's decision yesterday to issue the executive order. So that is one example. There was a longer list.
Well, Mr. Rose, you and I have been at this a long time. You know that I was a champion of dashboard cams at the point that there was active resistance on the part of line personnel. We got over that. The results of that, as far as I can see, have been civility on the part of the public towards the police, civility on the part of the police towards the public, and a record of what happens in these encounters. I have championed body cams. I understand all of the privacy issues that go with it. I am frankly astounded that when the polling that has been conducted by the CPC and the Monitor reflect overwhelming 80–90% approval, one of the groups that Mr. Weisel can speak to that has opposed this at every step of the way has been the CPC. I understand the privacy concerns, but you know what I hear now is we finally have come to the realization that the public demands that this happen so that we don't have situations as we've had within the last 2 weeks where we don't know what happened in an encounter. And it seems to me that it betrays the public's trust in the police department. I think, those officers, they honestly report what happened. If they didn't, then there needs to be consequences. If they did, then the public would better understand how those kinds of tragic situations arise. My frustration on this issue is apparent because I find we are working at cross purposes seemingly on this kind of mother knows best mentality that I don't think is appropriate in police practices.
Your Honor, I share the court's frustrations personally. I am here, however, not as Pete Holmes, the police reformer, as you noted, being at this for some time, but rather as the city's attorney. And this is that collective entities process. This is the position that the city finds itself in your court today. And every observation you've just made, there is no dispute from counsel standing before you.
All right. Why don't you go ahead and wrap up, sir?
Sure. I would want to, without belaboring bargaining too much further, I did want to give the court a 30,000-foot view of the status of those collective bargaining and related litigation. So SPOG has been here, the Seattle Police Officers Guild, for Your Honor. The Seattle Police Management Agency has not. But it is important to note that both unions jointly signed a letter to Your Honor on August 1, before our August 4 status conference, and stated that they were not opposed to police reform, but, quote, what both SPOG and SPMA oppose is any non-negotiated breach in its collective bargaining agreement or rights. That's at the docket of 306. So, as the court has reviewed already, we filed our proposed legislation in October, and then the SPMA filed its unfair labor practice complaint, which is still pending in front of the Public Employee Relations Commission, or PERC. On January 5, Your Honor, one day after our last status conference, PERC issued a preliminary ruling requiring the city to defend 6 claims of a failure to bargain in good faith. That is the gravamen of the ULP, the unfair labor practice. The very next day, this court approved conditionally that legislation that had been submitted in October. The city submitted the accountability legislation on June 21, and the very next day, again, these are kind of remarkable when you consider the milestones of the status conferences and then rulings on the ULP. The very next day, after we had submitted that proposed legislation, PERC rejected a proposal by the city to bifurcate the litigation and focus first on those matters directly related to police accountability. So with regard to SPOG, that pretty much encapsulates where we are with the ULP and SPMA, but with regard to SPOG, you will recall that there was a tentative agreement that had been voted down by the membership before our August 4 status conference. Union leadership was replaced at the same time, and bargaining has since been unproductive, admittedly. The city's labor negotiation team has made clear that the city is prepared to expedite bargaining on the accountability provisions in the legislation before the court, and my hope is that the court's approval of that legislation will help allow those negotiations to pick up steam. That hope, however, has to be tempered with a comment, again, about the executive order issued yesterday. The city and this court agree, Your Honor, that Black Lives Matter. The city and this court also agree that body cameras are a fundamental tool for building and maintaining community trust in law enforcement and for ensuring police accountability. This was all too clear in the aftermath of the tragic shooting of Charleena Lyles, where body cameras might have provided greater insights into the events which led to Ms. Lyles, the loss of Ms. Lyles' life. The executive began discussions in earnest early this year with SPOG to elevate body cams as a bargaining issue. And immediately following Charleena Lyles' death, we began to earnestly discuss the executive order itself. And it was signed yesterday by Mayor Murray. Absent any demonstrable progress in collective bargaining, Mayor Murray's order demonstrates that the city recognizes its obligation to provide a foundation for constitutional policing, and that it will, in some instances, require that the city act without further delay while continuing to bargain those effects with the unions. So finally, Your Honor, you have asked for an update on full and effective compliance with the consent decree.
I have. Let me just to set the stage for that. I have been hearing rumblings for some period of time that why don't we just declare victory and, all celebrate. It's not going to happen. I know we've had a change in administration in Washington. I understand that we're going to have a change in administration in Seattle because Mayor Murray is not running for re-election. The court is one of the few constants in this process. I would like not to be, but I am, and the court is. And consequently, we are not going to rush to just declare victory and walk away. We've sacrificed too many lives we've sacrificed too much effort to bring us to where we are now to prematurely just say, oh, well, we've got it done, let's move on. The consent decree is an order of the court, regardless of the point of view of various parties. It's under the court's control, and it's just not going to get terminated because it's expedient.
Your Honor, your comments are quite helpful to the parties. I would remind the court that in August, I observed that Your Honor and I were the last two signatories to the consent decree that are still in office. And indeed, rather prophetically, that has also become an issue in my own campaign. So I would submit that perhaps I wasn't speaking out of school there. Your Honor, I don't want to belabor the points here. I know that the court, I share a lot of the frustrations. I really do appreciate, and I know that the city appreciates the guidance that we've received today. That's why this status conference, I think, has been singularly important. That's why I do hope that as a result of this, we can together reassess. We'll have the parties, our unions together, and assess the direction that this consent decree is going. I, again, share Your Honor's comments, and I have the same goal, to see a reform of the very culture of policing in the city of Seattle. I have said before that I personally believe this is Seattle's first, best, and perhaps last opportunity to demonstrate that constitutional policing can be had, and I do not want to see this opportunity wasted. Thank you, Your Honor.
Mr. Diaz, I'm going to hear from Mr. Ruiz first.
Sure.
I've been picking on him, so I'll give him a chance to comment. Welcome back, sir.
Thank you, Your Honor. Good morning. My name is Isaac Ruiz. I am one of the co-chairs of the CPC. We have several commissioners in attendance today, and that includes co-chairs Reverend Harriet Walden and Enrique Gonzalez. We believe the legislation as it stands today meets the test that the court has articulated in the past. It moves Seattle toward policing, 1, that complies with the Constitution, 2, that allows police to be effective, and 3, that the people of the community can have confidence in.
So let me interrupt you the same way I interrupt Mr. Holmes. How do I know that it's going to be constitutional when I don't know what's going to happen with the accountability phase?
You don't know right now. And the way the court knows is as long as this consent decree case stays open, Your Honor has jurisdiction to review the final product.
But that puts me in the position of undoing something that would be better off left to be done once and done properly, as opposed to being done and then putting the court in the position of saying, no, you didn't get it right, try again. That's fundamentally where we are.
I think the principle is the same one that Your Honor applied before, which is to give guidance before the legislation was submitted to the City Council about whether the proposal by the mayor at the time, overall, looking at all the provisions together, was consistent with the letter and the spirit of the consent decree. I think Your Honor has done that before, and I don't think there is a problem with doing it again when we're reminded of the fact that this court will retain jurisdiction, so that whatever the final product is, Your Honor can do that same level of review, looking at the changes that get made, but also looking at those changes and how they fit with the global package to see whether the total accountability system package accomplishes those 3 aims that Your Honor articulated back in 2015.
Well, there are portions of the consent decree that I'm perfectly content with. I mean, it's clearly a work in progress, but I mean, we've made, the use of force investigations, clearly something that the court considered extremely important. Procedures in place. Now we're monitoring the compliance with that procedure. There was a suggestion in the news story recently that somehow we were participating in that, and that's not accurate, as I think everyone knows. But we do continue to review compliance with those procedures. Stops and detention, I see significant progress on. I noticed that the council recently, codified some of the bias-free policing practices. All of those are going forward because I think we know that we've come up with a final product, the courts reviewed it, now they're being implemented. The accountability package is different to me in that, one, I think it is fundamentally important. It's been a flashpoint for a long time. There have been improvements in it. I think, it's tremendous improvement with the Inspector General notion. But I don't know what's happening in this black hole over here, which Mr. Holmes shined the flashlight on and said, you don't want to look. That's a problem for me.
All right. I think we'd all like to take a peek, Your Honor, but we don't know what's going on there.
And we're not supposed to. So.
Right. And I will also say that I want to remember that back in August of 2015, Your Honor was concerned that even though the accountability legislation or accountability reforms were not part of the consent decree in the same ways that the other subjects that Your Honor has just identified are, that there was the potential that the accountability legislation could do things that affect the consent decree process. And Your Honor was careful to note that it wanted to look to see if anything in the accountability recommendations would conflict with the consent decree. And I guess what I'm saying is that ability remains now, and it will remain at the end of collective bargaining.
It is not a major point, but I think the consent decree speaks very clearly to supervision, which is
no, that's true, Your Honor.
Another effect of accountability.
Yeah, and it is also true that the legislation is a key deliverable under the consent decree in the sense that the settlement agreement assigned to the CPC evaluating and making recommendations about the accountability system, and the CPC did deliver that. The City Council, through the leadership of Councilmember Lorena Gonzalez, delivered this legislation, passed it unanimously. The mayor signed it, and that's why we're here today. We're following the process that Your Honor set out for us last year. And so we do ask that the court enter an order. What the precise terms of the order are, I do not know, but what we want, but here's what we want in non-legal terms. Just opening the door to move forward toward implementation. We recognize that there's a lot of work that still needs to be done. The process for appointing key accountability system leaders is just now going to begin. Budget questions remain unanswered. The old accountability system, it hasn't been dismantled, but it's under a lot of stress, as Your Honor knows. We have both an interim OPA director and an interim OPA auditor. And meanwhile, as the court has observed, the uncertainty of the collective bargaining process is hanging over this legislation. And so everyone in this courtroom knows, as Your Honor has said, that it's not time to declare victory. We cannot say mission accomplished. What we want to see, and what I think the parties in the case want to see, is the complete accountability system up and running as soon as possible. We're thinking of John T. Williams and others who should still be here with us. We're thinking of people like Reverend Harriet Walden, who have devoted their lives to the cause of changing police culture in our city. We are thinking of Charlena Lyles and her family. And our bottom line, Your Honor, is Seattle has been debating these reforms for years. And have the reforms benefited from the investment and time that has been made? Absolutely. The time spent crafting, refining, and reviewing this legislation is literally impossible to count. There are a lot of people in this courtroom today who haven't been introduced to the court, who have spent thousands of hours on this legislation. And here we are. The CPC made its recommendations. The City Council refined and voted for it unanimously. The mayor signed it. The public supports it. And we hope the court will say it can go forward. And after that, whatever needs to be done to fully implement this legislation, we hope it can be done without delay. Whatever obstacles stand in the way, and there are obstacles, Your Honor, we think it's essential that those obstacles be addressed through proper channels, whatever those may be. And resolved as soon as possible. And of course, this court maintains its jurisdiction. This legislation has momentum. We can't let this moment pass. let's get this implemented, and we want the court's permission to move forward.
Well, what you're going to get is we're going to start the process of identifying for the court what are the areas that are still open. The amended legislation contains provisions that I've not seen before and are going to get close scrutiny. I would remind you, because it sticks with me, that the reason we don't have body cameras in part has been the consistent opposition of the CPC to body cameras based on privacy concerns. And now we have the child's shooting, and people are out saying, well, where are the body cameras? The police must be responsible that we don't have body cameras. I have real trouble with that.
The position that the CPC took in its filing regarding body cameras, Your Honor, was a revision in policy. We did not propose that the body cams not be implemented. We proposed a revision in the policy which Your Honor did not accept, and that's fine. But the CPC is not standing in the way of body camera implementation. This is a collective bargaining issue.
You, sir, you're a recent member of the CPC. There are a lot of people sitting out there in the audience who've been here for a long time. We can go back and look at the record where you've been on the record as saying, do not implement body cameras because of privacy concerns. And please don't come in and say, it's not us standing in the way. You were. And now it's troublesome to me that all of a sudden we're hearing it's all somebody else's fault. This is a frustration for me. And you know, I'm not blaming you for it, but I think you need to recognize you have a role in this. You had an advisory role, and your advice was, don't do it until we can resolve these issues. You can call it a pause. That was a convenient term to use. But that was the position you were taking, was don't implement this. And I don't know if it would have made a difference, but at least I'd know what happened in these instances. But for a number of parties who have taken the position that, you know, we have too much of a privacy interest in it. So that's my rejoinder to your statement.
All right, Your Honor. I'm not sure that there's anything for me to say in response to that.
Probably there isn't.
I mean, I have gone back and I've looked at the record from before my involvement, and I do think that there are important privacy concerns.
Well, remember that lives matter also.
We know that just as well as anyone else, Your Honor. We, you know, and I think Your Honor knows that we know that. We take the issue very seriously. We take the issue of marginalized communities who are disproportionately affected by certain police practices very seriously, and that includes body cameras. And those are some of the interests that we raised during the process. At this time, the body camera issue is not really the reason we're here today. What we want today is permission, Your Honor, after the court reviews the changes in the legislation, which Your Honor should do, but also look at those changes and how they affect the entire package. And we ask for a ruling that Your Honor believes that the accountability legislation, taken as a whole, is consistent with the aims of the consent decree.
All right. Thank you, sir. Mr. Diaz, now you get your chance.
Thank you, Your Honor. May it please the court, you've given us some hint at what is concerning to you right now about the motion before you, and I want to address that head on. But if you indulge me for 20 seconds, I just want to say that on behalf of the Department of Justice and the U.S. Attorney's Office here in Seattle, I want to begin by recognizing the impact that the officer-involved shooting death of Charlena Lyles has had on so many. Words are not up to the task at these kinds of moments, but they are what we have. I want to convey our collective, most sincere condolences to Ms. Lyles' family and friends and everyone who was impacted by the shooting in countless ways. With that, Your Honor, your question ultimately goes to why am I shooting at a moving target here? And
Well, let me ask you a more fundamental
Sure.
question. And you want to defer this to Mr. Mygat. Is the position of the Department of Justice that the City of Seattle is in full compliance at this time?
This question, there's a distinction that has to be made before I can answer that question. Full and effective compliance is different from termination.
I
No-
understand that. but
nobody's-
I want to know the answer.
Yep.
Full compliance. I didn't ask about termination.
Yep. Full and effective compliance, as we define it, is a process. And that process was started in September 2015 with the third-year monitoring plan laying out a series of systemic assessments that the monitoring team and the DOJ together and collaboratively engaged in over a year and a half. That process was to cover every aspect of the consent decree. And that's what was stated in the monitoring reports, and that's what the position we took. We are now done at the end of that. We are the SPD is 10 for 10 at this point. They didn't pass a couple of them. They've remediated, and they're now back. But right now, the question is, what's next? Are we in a position to declare full and effective compliance? Not termination, but full and effective compliance with the terms of the consent decree. And that's a conversation I prefer, and Mr. McGatt would say the same thing. That's a conversation that we're going to have with the monitoring team, with the city, as early as tomorrow. And the monitoring team is going to file something on August 10th, which gives its views, and will give us the opportunity to brief up our position on whether or not they are presently in full and effective compliance.
Well, I think you need to be careful. You inadvertently suggested that you were going to have your interpretation of the consent decree was the terms of the consent decree, and those are two quite different subjects. I'm going to re-ask my question, which
Sure.
is because I think the public, is entitled to know. We have heard, based on sort of national policy statements from the Attorney General and others, that consent decrees bind the police in an unnecessary way. There's a consent decree that's in place here. Is it the position of the Department of Justice that this consent decree should be terminated?
No,
All right.
it's
Thank
not
you.
our position. Definitively, it's not our position.
I don't see how you can reach any other conclusion given I have the view that there is no perfect police force. That when we have citizens who we ask to protect us and we give them weapons and they go out into dangerous situations, that the possibility, I stress the possibility, of tragedies can occur. We train to avoid that situation. That doesn't extinguish the possibility. But on the other hand, I want to ensure that, the Seattle Police Department is a model of doing it right. And events of the last couple of months suggest we've still got a ways to go. And this discussion of, we're 10 out of 10 or we're almost there, it belies the fact that we continue to have these incidents and we need to learn from them. Are we conducting the use of force investigation in regards to the Lyle shooting in a proper manner? That's the role of the monitor. That's the role of the court. We don't do the investigation. We make sure that it's done in accordance with the policies that are in place. And I'm troubled with this notion that all of a sudden the whole discussion is full and effective compliance and 2-year waiting period and then termination. That sounds to me like a rush, and I'm not going to permit a rush to termination. And you've answered this question. That's my rejoinder to it.
Okay. Thank you, Your Honor. We agree with as we've discussed this internally a lot, we agree with what you're saying. No one is walking away. No one is rushing. There's just a procedural and a consent decree-based conversation that we have to have with the city and with the monitoring team to see where we are now, given the 10 systemic assessments that have been completed to date, and where we go based upon the consent decree. I did want to turn...
Let me ask you one other
Sure.
question. How do you propose we conduct a full compliance review of accountability when we don't know what accountability is yet?
Right. And that's the question I wanted to turn to, Your Honor. I think our answer is that the short answer is any changes to the legislation or any changes to legislation that affect potentially the consent decree are going to be brought before the court. If we're grounded in the consent decree and we look at paragraphs 226 and 227 to guide this, there's a process in there. In 227, there is a notice requirement. When the city determines that something has become, quote-unquote, subject to collective bargaining, they're required to notify the Department of Justice. In turn, the Department of Justice is obligated by the consent decree Your Honor signed to then seek quote-unquote alternate means, ... if necessary, right? And so there's going to be a notice when Mr. Holmes and the city, whatever point in the process they reach, that they've determined, or the PERC has determined, the Public Employment Relations Commission determines that the issues in the accountability legislation are subject to collective bargaining. There's going to be a requirement to provide us notice, and then there's a requirement on us to work through that. And so anything, again, to repeat the short answer, anything that changes the legislation is going to come back through this court after a notice and a meet and confer between the parties. So yes, there might be a third bite at the apple, unfortunately, Your Honor, but there might not be. And we just don't know that right now. But what I can say, and I think this is really important, because it's our understanding that at present, based upon the SPMA's, the Management Association's ULP, their unfair labor practice, that none of the reforms implemented pursuant to the specific terms of the consent decree are being prevented from being implemented. Because the city, we're just going off information that we've gotten from the city and is publicly available, is that the PERC has determined that any challenge to any action that the city took before April 2016 is time barred. They didn't bring a ULP timely, and it can only go back 6 months. What that means for us, I think, Your Honor, and it should give you some comfort, is that all the policies, all the training, all the structures that we have set up and the court has approved, including the FIT, the Force Investigation Team, the FRB, the Force Review Board, the CIT program in whole, the Community Police Commission, the CIC, they are continuing to be implemented and are protected from this unfair labor practice complaint because all of that stuff occurred before April 2016. So I think we're going to have a chance at the appropriate time after notice and after a meet and confer to see if there's anything else post-April 16th that might be subject to collective bargaining, and then we'll come back to the court. I don't know if that's helpful, Your Honor.
It's helpful. It restates what I probably inarticulately stated, which is it seems to me we've made good progress in a lot of areas, and we've implemented. And as far as I know, I'm not privy to the challenges, but I've not seen any challenges other than these, what's called in this consent decree supervision, and which we've taken to calling accountability. Mm-hmm. And in that, there's lots of questions. Mm-hmm. Unfortunately, that accountability aspect sweeps broadly, and it picks up something as non-accountability related as body cameras. Mm-hmm. And that's exactly the kind of situation that I'm worried about, is what else is out there. I mean, are we going to have an objection to the Inspector General process, which the court fully supports? And as far as I know, the parties fully support. So that's what my concern is. I agree with you that we're dealing with a distinct in-play portion. There are other aspects of this where we are simply monitoring to make sure that we're in compliance. And once we've determined that there is compliance, then, I'm happy to say, we've now 7/10 of the way there. But I want to make sure that when we get there, we have the entire interrelated processes all working together. And that's where I am today, and I lack that sense of certainty that we're doing that because of activities that are outside the review of the court. Yep.
And just a few more specific points around it. We don't object to what your next immediate step is, which is, taking a look at, you've asked Mr. Holmes for the list referenced in footnote 78, which I appreciate that you've read up to footnote 78. But in going through that process, identifying what's in and what's out and what still could be changed. But at the end of the day, I think a couple of points. Again, we're going to have another bite at this apple. If there are changes, if there's anything. And second, the accountability stuff, to the extent we can start dividing it up, there is some stuff in the accountability legislation which is just codifying the policies and training that we have here developed together. That stuff should be unobjectionable. There's other stuff that's new, and we'll have to see how that affects the overall structure. But at the end of the day, Your Honor, part of this isn't the first time we've taken together this sort of leap of faith. When you approved the Force Review Board, for example, we didn't know how exactly that was going to work. there are a million minor questions that don't go to the core of it, but they had to be answered through practice. And we, with the monitoring team, with Mr. Ehrlichman at the Force Review Board, we worked through all those processes together in real time. When an issue came up, we would then, and it required a policy change, we would come before you and say, look, here's a material change to the Force Review Board that you approved. We need to change this. Does this look okay? And then we would argue about it. Sometimes we debate with the CPC about it. Sometimes we debate with the city about it. But at the end of the day, we would come to you again. And learning through practice, I think, is I think, it wouldn't be the first time we did that in this case. With that, Your Honor, I think I've addressed the topics that you wish to address. If you have no further questions, that's all.
What is the impact if the court withholds approval until after the collective bargaining agreement is finalized? Or collective bargaining negotiations?
It depends. I think I'm not an expert in this area. I mean, again, our focus has only been, is this in conflict with the terms and purposes of the consent decree? That was the assignment given to us. You give us DOJ's opinion on this. So I'm not an expert. My understanding is it depends, the impact would depend on how broad that order is. Are we stopping everything related to the accountability legislation, or are we stopping only those things that could impact the consent decree? I mean, like I said, codifying certain things that are clearly not related to the consent decree, it would put a pause and we'd lose momentum, I think, a little bit, in having at least some processes go forward.
You're beginning to sound like an NFL announcer on this momentum question. I mean, this is of such significance that I'm not concerned we're going to lose momentum.
Yeah.
And we need only look at the issues that have arisen in the last bit to understand that the public's not going to lose interest in this. I mean, they ultimately are the reason that we're here. Mm-hmm. So I'm less troubled by the losing momentum than I am doing something in some rush to achieve momentum that we ultimately have to go back and undo.
Mm-hmm. I mean, at the end of the day, Your Honor, and this will be my final comment on your question, is at the end of the day, it goes back to what is our role here, both DOJ's and I think the courts. And I think it's to implement your court order here. And the question is, does the accountability legislation impact the court order significantly enough to delay it or to take our time, wait for collective bargaining, which, again, it's a black box. We're not part of that. And for us, again, we're taking a narrow focus, and whether it was the last administration or this administration, it's a narrow focus on the consent decree. Is this going to violate the terms and purposes of the consent decree? And we don't see the legislation as written doing that, and that's why we are supportive of it.
All right. Thank you.
Thank you, Your Honor.
Counsel, I think over the course of a period of time with the parties, I've explained everything that I'm interested in. Mr. Holmes, I'll look forward to receiving your list, and to the extent that we look at it and conduct some negotiations, which we do, at least consultations, with the parties, we may be able to come up with a list of provisions in the ordinance that can go forward, and happy to do that. And that seems to me that is about as far as we can go at this time.
Thank you, Ron.
Mr. Reeves, anything further?
No, thank you, Your Honor.
All right. Mr. Holmes?
No, Your Honor, thank you. We are meeting hopefully tomorrow with the United States, and we'll prioritize this list at the court's request.
Mr. Diaz?
Nothing further, Your Honor.
All right. Then we will be in recess. Thank you, counsel. Very informative.